Hi, everyone. Harry here to talk about the Voting Rights Act and a decision by the U.S. Supreme Court that actually puts on hold for now and through the midterms a decision by the Eighth Circuit that would have allowed the state of North Dakota to dilute the votes of Native Americans there. Okay, Section 2 and Section 5 have always been the big ticket items in the Voting Rights Act, which was passed as a landmark piece of legislation in the 60s. As I'll explain in a bit, Section 5 is pretty much out of business, so all the focus is on Section 2. Section 2 sets up an effects test, importantly, that says in the case, for example, which is the paradigm of a redistricting, if the effect of the redistricting is to dilute the vote of a particular cognizable minority group, like Native Americans, you can't do it. And even if you can show, well, I had nothing against them, I just wanted to increase my own power, which would be typically what Republicans would now be saying. I'm not racist, I'm just ambitious. But Section 2 stands to prevent exactly that kind of stratagem. Okay, so in this case, this is a case brought under Section 2, the one that still has viability. And what happened is the state of North Dakota, the Republicans got control of the reapportionment process, so it was crass and political. Some states, of course, have served it up for independent, nonpartisan commissions, but that's not always the case, and that's when you get Section 2 claims. And they redrew the lines so that the voting power of Native Americans was diluted. You had one district where, in fact, one of the plaintiffs had been redistricted out. She doesn't even have a district to stand election for. So they said, this is a violation of Section 2. The district court agreed it's a violation of Section 2 and put a hold on that reapportionment map for now while the case continues to go through the merits. But the district court said, provisionally, I'm putting a hold on it, so we return to the status quo while we have a bigger trial on the merits. That went up to the Eighth Circuit, which reversed. A 2-to-1 vote said, basically, people cannot sue under the Section 2 of the Voting Rights Act. The Voting Rights Act is there. It says you can't dilute on account of race. But Congress did not intend to let people who are aggrieved by it sue. Only a state, perhaps, could bring a cause of action. So the Eighth Circuit, to get a little technical, said Section 2 itself doesn't let you sue. And 1983, a sort of all-purpose section that lets you sue for violations of constitutional rights. And we are talking about the 15th Amendment here and the principle that you can't dilute on the basis of race. That underlies it as well, but it doesn't matter. You can't bring a case. So the actual holding is private plaintiffs can't bring a case, making Section 2 nigh unto a nullity. And Section 5 already is, as I'll explain in a bit. It was a 2-to-1 decision. It's noteworthy that the one is a very conservative but very smart judge, Stephen Colleton, who clerked for Chief Justice Rehnquist, was a U.S. attorney, and it's, when he dissents and says they've really abandoned the law, that's something that I think is eye-catching. And indeed, it seems to have caught the eye of 6 justices of the Supreme Court, because most recently what happened here is the same kind of move that the court's done repeatedly to the detriment of liberal or Democratic voters. Here it did to the detriment of the Republicans in North Dakota, because what the court said, without explanation, and the same infirmities that the shadow docket always has, we're removing the stay that the Eighth Circuit put on the stay that the district court imposed. In other words, what the district court says, which is this doesn't go into effect for now. That's what stands. The Eighth Circuit doesn't stand. Now, it will all continue to be worked out on the merits, but while it is, the plan does not go into effect, and that has immediate implications because, for one, the person one of the plaintiffs, now can remain a member unless she loses her seat for some reason, whereas under the plan, she was just gone. She had no district to run in. And, we're talking about a national environment where every seat translates into, a vote. And right now there's a razor's edge advantage for Republicans. So everything is very, very vigorously fought. There's an effort that the Republicans are launching, I think, in Texas to get a few more seats out. And that's all like absolutely existential when you think about the 2026 election. Okay, to just take a step back. So what the Supreme Court did was say that the Eighth Circuit's imposition of a stay on the district court is gone. 3 members of the Supreme Court, can you guess? Alito, Thomas, and Gorsuch dissented. They said, we would have left the Eighth Circuit stay in effect, but the other 6 say, and that would have meant, of course, that the 2026 election would have been decided with this new configuration. But 6 members of the Supreme Court say no. The Eighth Circuit stay is off the books unless and until we decide the case on the merits or we decide not to decide it, which is what they typically do in the shadow docket. So temporary, but very important impact. The North Dakota map stays the same. However, there is now pending out there this issue of, does the Section 2 of the Voting Rights Act provide for some kind of private right of action, which means persons who are hurt can actually bring the case. It's not exactly constitutional standing. It's, did Congress intend to permit the law to have a private remedy? And now, just to very quickly end with the landscape of the Voting Rights Act. Landmark voting rights legislation, part of the Great Society, passed in the early 60s, and Section 5 was by far the most important, and it held that identified states, a dozen or so, who had a history of discrimination on the basis of race, and you read about them in high school, that poll taxes or reading tests or whatever, but only for African American voters. When they would make any changes, they'd have to clear it with the Voting Rights Commission in D.C., any kinds of changes to their voting procedures. And that was, over the years, by far the most important kind of enforcement of the constitutional guarantee that votes would not be abridged on account of race. Then a few years ago, the Supreme Court said, it's been too long. The boot of Congress should no longer be on the neck of these states. They've, expiated their sins or whatever, and they just basically, by, just said, we're making this go away now. If Congress wants to repass a whole new statute doing it, okay, fine. The odds of that, of course, are 0 or 0.01%. It's one thing to just continue to reauthorize, another to pass a whole new Voting Rights Act. This is not the Congress of 1963. So what that means basically is Section 5 is moribund, and maybe will always be that. There's no longer a single state to whom it applies. Congress hasn't done anything. That means all the action is and remains somewhat lesser, but still remains in Section 2. So this issue becomes very important because Section 2 is the locus of enforcement. For now, North Dakota won't have any changes, and so that's, that settles things for 2026. But that issue hovering in the Eighth Circuit, if they decide it, it will possibly go to the Supreme Court, where there are already 3 votes to take the same position of the Eighth Circuit and say there may be a right there, but nobody can sue under it, and that would essentially take the crippled Voting Rights Act and, just completely decapitate it. So that's the overall stakes of the issue. The immediate stakes are that the map will remain in place because the Supreme Court agrees with the district court, the Steve Colleton, the more liberal interpretation, and doesn't let the Eighth Circuit just willy-nilly on a stay take it away. They have to go through the whole process. So no change between now and 2026, but on your sort of Supreme Court horizon and agenda, the possibility of an issue that could result in the basic extinction of the Voting Rights Act overall. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.